So, on behalf of the Citizens Coalition for Electoral Democracy in Uganda, a coalition of 972 civil society organizations and 27,000 individuals who came together to promote the cause of electoral democracy, I read this statement. The post-election period has been characterized by tension surrounding disappearing Ugandans. On February 3rd, 2021, a list of over 213 missing Ugandans was released by the National Unity Platform. Many families were reportedly looking for their relatives who had been picked up by plainclothed persons in drones and driven to unknown places. In a tweet by Robert Chagulanyi Sentamu, the president of the National Unity Platform, posted on Sunday, January 31st, 2021 at 11:30 p.m., he said Pandagari is back in full force. Political activists and ordinary citizens now dread these vehicles called drones. Countless Ugandans have been abducted and taken to unknown places. Kenneth Mukasa, a comrade, is the latest victim, kidnapped yesterday. No one knows where he is. It was soon established by the media that it is true families and citizens were living in constant fear for their lives and their loved ones. These people, according to press reports, were disappearing because of their political affiliations. This is a direct infringement of their rights as guaranteed in Article 29 of the Constitution that provides for the right to assemble and associate with the political thinking of one's choice. Ugandans are hurting. Families have been weeping for weeks. All they desire are answers from the state on the whereabouts of their relatives. When the media reports escalated, President Yoweri Museveni issued a statement to the effect that every Ugandan's life will be accounted for. The president's statement was very encouraging, but questions around abducted Ugandans still abound. The parliament has debated the issue twice. The police security forces have been asked to account for all the Ugandans on the NUP list, but this accountability has not come through yet. The Minister of Internal Affairs, General J.J. Odong, while appearing on the floor of Parliament in the recent past, first presented a list of 44 people whom he said the police had arrested. He later returned with a list of 177 persons whom he said that were in custody of the police. The 177 were part of the names on the list of 213 missing persons that NUP had earlier on released. The minister said the 177 were arrested for being in possession of military stores, or were said to have been planning insurrection after the 2021 general elections. While CCEDU acknowledges that insurrection is unconstitutional, the organization remains cognizant of the non-derogable right to a fair hearing. Article 42 of the Constitution provides that every person has a right to a fair hearing, speedy and public hearing before an independent and impartial court or tribunal. This is in regard to both civil cases and criminal charges. Therefore, all people who were arrested by security forces and subsequently reported as missing by their relatives and families have to be subjected to the two cardinal principles of the Constitution provided by the rule of law: the non-derogable right of the rule of law, the non-derogable right of the writ of habeas corpus, that is the right to be produced in court within the mandatory 48 hours, and the right to a fair hearing. Anything short of that means that the forces are acting outside the constitutionally provided means of resolving conflict. The purpose for a writ of habeas corpus is to review the legality of the applicant's arrest, imprisonment, and detention, and challenge the authority of the prison or jail warden to continue holding that applicant. The application is issued when a person is held without charges or is denied due process, and that is what we've seen for most of the people that went disappearing, they were denied due process, and we are demanding that there must be due process. CCEDU is concerned that the majority of kidnapped persons are the youth, and for a long time they have been skeptical of participating in electoral processes. Now that they came out in big numbers and exercised their right to participate as guaranteed in Article 38, which states that every citizen has a right to participate in the affairs of government individually or through his or her representative in accordance with the law, and Article 29 of the Constitution, have been victimized for the same. These are steps in the backward direction of an electoral democracy that CCEDU has so overly defended and promoted over the years. Stated in this statement is within the Constitution. If the government believes in the Constitution that they put in place to promote the rule of law in Uganda, then we are not opposition. We are just reminding them as the duty bearers that this is what is in the Constitution. In the Constitution, the writ of habeas corpus is a non-derogable right. A non-derogable right means it is your right constitutionally given to you and must be respected by the people who hold power on behalf of Ugandans. So there is no way of saying we are opposition. We are just Ugandans who are empowered and know what the Constitution says to defend us as a people. That one they should listen and know. So what CCEDU has decided to do is to be the intermediary between these lawyers and the people by collecting the information from the people, registering the cases, documenting them perfectly, and then sending them to the lawyers for them to attain justice. The first journey to healing is attainment of justice. There cannot be trust without justice. There cannot be equality without justice. And there are two things we could mention about peaceful demonstrations. The Constitution in Article 29 actually provides for peaceful demonstrations. Article 32 of the Police Act was declared unconstitutional by the Constitutional Court. And Article 32 was providing that Ugandans can be allowed to hold peaceful demonstrations. The case had been taken to court to pronounce itself on whether it was correct for Ugandans to undertake peaceful demonstrations or not. And the court sat and declared and said Ugandans can actually carry out peaceful demonstrations. However, the only catch-22 in peaceful demonstrations is that they can so easily turn into unpeaceful demonstrations if not credibly handled. So the important thing for us as a coalition is not the demonstrations. What is important for us as a coalition is for the political accountability to take place, for justice to happen, and for trust to be built across the different players on the political scene. And those who have lost their husbands and their children, I feel for them. Kawesi, I do feel for them. And the rest of the world should know I cry with them. The reason I decided to put my head here and sit and release this statement is because I feel for them. A mother cannot be told you can't find your child. You can't find your husband. A wife cannot be told you gave birth. Your husband will never come back. He's not on the list. We don't know whether he's alive or he's not alive. It pains. But as much as it pains mothers, as much as it pains wives, it also pains the other ordinary Ugandans. And for us who promote electoral democracy, we promote it for all sectors of people, the youth, the women, the mothers, the wives. But truly, I do feel for the women. And it is unfortunate. I hope the government, the duty bearers, will account for every single missing son, every single missing husband. And then we can begin on a healing process. CCEDU unequivocally demands that the authorities account for each of the missing persons that have been reported by families and friends. We have opened a phone line 0704 221 605 to which relatives can call and report their lost friends, and family. We will follow these cases to the letter. We shall compile the cases and submit them to a C of our network of public interest litigation lawyers, but we shall also follow the cases with the police. I thank you.